ACI Arbitration Council of India provides policy, standards and depository of awards. AI Arbitration institutions, body of persons form their own rules of arbitration. Examples: ICA, Indian Council of Arbitration; ICC, International Chamber of Commerce; MCIA, Mumbai Center for International Arbitration; NAC, Nani Palkiwala Arbitration Center; DIAC, Delhi International Arbitration Center; UNCITRAL, United Nations Commission on International Trade Laws; 21A Arbitration, whether or not administered by permanent arbitral institute or not; 21B Arbitration Agreement under Section 7; 21C Award including interim award; 21CA Arbitral Institution designated by Supreme Court and High Court; 21D Arbitration Tribunal; 21E Constitution. For a domestic one, it is civil court; international one, it is high court. Section 11 Appointment of arbitrator, domestic high court, international Supreme Court. International commercial arbitration. Non-resident, one party should be at least non-resident, either Indian, individual, body corporate, company or government. Section 2 Clause 2 Scope. Section 9 Interim measures by court. Section 27 Court assistance to take evidence. Section 37 1A Appeal under Section 9 request. Balco case versus Kaiser Aluminium. Indian courts have power even if the place of arbitration is outside India. Section 7 Arbitration Agreement. Section 8 Power to refer parties to arbitration where agreement exists. Section 9 Interim orders by court. Then Shakti Bhog versus Kerala Koala Shapi Electronic in writing arbitration agreement under Section 7. First statement of defense, you have to object. Compulsorily refer to arbitration. If both agree, no objection. First court will continue. Case Mahesh Kumar versus Rajasthan SRTC. Second case HPCL versus Pink City Petrol. Section 9 Minor. Appoint a guardian. Status quo of property. No sale, no TPA, no transfer. Interim order plus within 90 days arbitration should start. Once tribunal is on, no court can give interim orders. Interim orders by administrative tribunal under Section 17. It is same as Section 9, the same powers as the court. Court will order if 80 interim under Section 17 is not effective. Parties they appoint under Section 11 by court. If appointment is to be done, it is HC for domestic, SC for international. Section 13 Challenge arbitration appointment. Challenge within 15 days of appointment. Later Section 34 Challenge the award only. Section 9 is equal to Section 17. Both have interim powers. Section 9 for court, Section 17 for arbitration tribunal. Procedure 1. Place or seat of arbitration. 2nd. Statement of claim and statement of defense within 6 months. 3rd. Hearing, written proceedings. 4th. Default of a party, claimant, then terminate. If the default of a party or defense, then award ex parte. Then expert appointment, then court help and for recording of evidence under Section 27. Next, decision or award under Section 29. Time limit, Section 29A, award within 12 months, extension 6 months possible. Section 29B, fast track within 6 months. No oral, only sole arbitrator. Section 30, settlement among parties while arbitration is going on, award based on settlement. Section 31, award in writing, signed by arbitration tribunal, reason or speaking order, date and place, signed and copy to each party. Interim orders, award or cost and interest plus expenses. No reasoned order if settled by parties, if parties don't want reason. Rate of interest is prevailing rate plus 2%. Section 34, set aside award. Section 39. 35, finality of award. Section 36, enforcement of award. Section 37, appealable order. Section 34, breakup. 34.2 and 34.3. 34.2 is party gives the proof of incapacity of the party, invalid agreement, lack of notice regarding appointment of arbitrator, arbitrating proceedings, unable to present his case, lack of jurisdiction, and beyond arbitration agreement composition of the tribunal or arbitration proceedings. They are beyond the agreement. An agreement not according to part 1. Next, if the court finds dispute, then not arbitrable, dispute is not arbitrable, or dispute is against public policy violated, then court finds it patent illegality, that is against Indian laws in India. 34.3, limitation is 3 months. That is summary of arbitration. Now, process of arbitration. Arbitration agreement, first step. Second, choice of arbitrator, second step. Choice of law, third step. Seat of arbitration, fourth step. Procedure, fifth step. Reference to arbitration by court, sixth step. Interim relief, seventh step. Extent of judicial intervention, eighth step. Appeal against the order, ninth step. Award, 10th step. Challenge the award, 11th step. And enforcement of the award, 12th step. Venue versus seat of arbitration. Section 20, seat of arbitration versus place of arbitration. Relevant to jurisdiction, seat of arbitration plus venues of arbitration. Seat decides the loss. Only one seat of arbitration can be there for an arbitration agreement. What is arbitration? It is a mechanism for settlement of disputes, ADR, based on consent, private procedure, final and binding, determination of rights and obligations of parties. Mediation, he facilitation by third party as a mediator. Section 89 plus order, CPC 1908, order 10, 1A, 1B, 1C. Conciliation, section 61 of Arbitration and Conciliation Act, 61 to 81. Settlement by third party plus authenticated by conciliator has the status of decree of court. Arbitration, section 1 to 60, Arbitration Act 1996, third party adjudicating a dispute. Next, cases.